All right, yes, Mr. Krieger.
Good morning, Your Honors. Arthur Krieger, representing the plaintiffs' appellants, trustees. This case involves the applicability of the 8-year zoning freeze, where a subdivision plan, or actually one for each of 2 properties owned by the 2 realty trusts, was constructively approved because the planning board didn't take the requisite action, but the town clerk failed to issue the certificate of constructive approval. Our position is that the zoning freeze, regardless of any implications for subdivision control, the zoning freeze attaches to the properties shown on those plans.
What about, though, the fact that you lost the mandamus action?
Well, had we won the mandamus action, then this issue wouldn't have arisen because mandamus would have required the town clerk to issue the certificate, and that would have been that. It's only that the appeals court, while finding the town clerk's reasons incorrect, found that the mandamus action had been brought too late. Right. It's only for that reason that we're here, that we cannot now obtain, at least by order of the court, the certificate from the town clerk.
But I guess my question is, quite apart from the merits of whether the appeals court, in this case, or Kraftschuk, interpreted the Section 6 correctly, aren't you, in a way, out of luck because the mandamus on latches, I mean, really on timeliness grounds? It didn't have anything to do with the merits of the...
That's correct. The Superior Court had found a constructive approval. The appeals court did not touch that determination, found the town clerk's reasons incorrect, as I mentioned, and decided on timeliness grounds. That's absolutely right. And that stops the subdivision for subdivision control purposes. That is, without the certificate, it's clear that the plan cannot be recorded under Section 81X, and therefore the trustees cannot sell lots off those plans and build the subdivision. But the point of this appeal is this.
I see your point. Because if the zoning freeze applied, you could submit another plan. Is that what you're saying?
That's right. If the zoning freeze applied, we would be operating under the old rules, which were far less restrictive, far less onerous with regard to frontage, which is the zoning amendment we're talking about.
But I'm sorry to keep at you, but if the mandamus was rejected because it wasn't brought for timeliness reasons, which means you don't have a certificate, right?
Correct.
And doesn't the zoning freeze depend on there being a certificate?
Well, that's the entire basis of this appeal. That's the entire issue before the court. And our argument for the following reasons is that it does not.
I mean, even if, I guess I'm just saying, even if you think what the appeals court, how they interpreted the statute was incorrect, it seems to me you still get down to that bottom line, don't you?
Well, the interpretation was that we do need the certificate to have final approval and therefore the zoning freeze. Our argument is that we do not need the certificate. We need it to proceed under subdivision control, recording the plan, as I mentioned, and proceeding off of that, but we do not need it for zoning purposes for several reasons. Number one is the distinction between subdivision control and zoning recognized by this court in the Heritage Park case. The town clerk certificate is required for recording and sale, but there's no reason to make it required for the zoning freeze. That's the implication of the Broken Stone case, Mass Broken Stone, where the court recognized that the developer may never record the plan or even care about that plan, can file a subdivision plan just to obtain the zoning freeze, and yet is still entitled to that freeze because the freeze protects the land and not any particular plan. That's one reason that the appeals court's automatic importation of its conclusion under subdivision control to the zoning freeze issue is wrong. Number two is what the appeals court's opinion does is it elevates the town clerk's role into a position that the legislature never intended. The town clerk's certificates and other actions are merely ministerial. They're not part of the...
Well, but that goes to the whole mandamus point. I guess the appeals court agreed with you that, in fact, the mandamus action was an appropriate action. It just wasn't timely brought.
Correct.
Yeah.
So, but the point is that the town clerk's action is not discretionary. It is subject to mandamus, and it is not...
But if you don't bring the mandamus in a timely way, I mean,
That's correct. But the question is here, for purposes of the zoning freeze, how significant is the absence of the town clerk's certificate? Is it significant? And to say it is significant, in fact, to say it is determinative, as the appeals court said, elevates the town clerk's ministerial action into something that now is affecting substantive rights.
Well, isn't the certificate a statement that we have finally reached a final decision in this process?
Under one of the scenarios laid out in Section 81V, the certificate merely recites that, as you said, Justice Ireland, the court, if there was an appeal, the court has found that the appeal has ended, that there has been final approval. And now the certificate recites, I've got those court papers, and there has, in fact, been final approval. It is just a recitation of the fact that the approval had become final by virtue of the court decision. And that is the clear language of the second sentence of 81V. The court papers state that the appeal, quote, has become final. The clerk's certificate then recites that. It is not the clerk's certificate that determines the finality, nor, as a result, determines whether the zoning freeze applies, that is, the substantive rights of the parties, as opposed to the trigger of deadlines or procedural matters. One of the defendants in one of their briefs called the town clerk the quarterback. That analogy is not apt.
But it seems to me that the trouble with that is that the zoning freeze statute specifically says that the 8-year freeze, and I know that there's two stages here,
Right.
that the 8-year freeze commences as of the date of the planning board's endorsement. Let's say the planning board voted to finally approve the plan, but then refused to sign the plan. Your 8-year freeze would not become operative. You would have to file a mandamus action. If you didn't file the mandamus action in time, you lose the freeze.
Correct. Several responses. Number one, the zoning statute refers only to that endorsement. It does not refer to what the appeals court thought was the perilous situation of a town clerk certificate. So it almost proves too much to say that that's what it refers to, because 48 Section 6 doesn't actually refer to zoning freeze off a constructive plan at all, and yet all the cases and all the parties assume that it's equally applicable. But the scenario you raised would be highly unusual, because the hypothesis is that the planning board approved the plan. It found the plan acceptable, it was comfortable with the plan, it approved it. There's no reason to think it would withhold an endorsement in that situation.
Except that the statute, the language of the statute specifically links the 8-year freeze to the handwriting of the 3 or 4 members of the planning board.
That's correct. And that clarity may be welcome clarity in that scenario where the planning board has approved it, but it doesn't mean that in a situation where the planning board is opposed to the plan or neglects the plan or stonewalls on the plan, that is, there is a constructive approval because for one reason or another it missed the deadline. In that situation, it would be far more significant and far more jeopardizing to the developer's rights to say that the town clerk certificate, again, triggers that 8-year freeze.
I guess this is what Justice Spina, maybe I'm asking the same question, but I guess the question is, let's say that, yes, the town clerk's doing of the certificate is a ministerial act, as you say. But for whatever reason, the town clerk doesn't do it. And it's a 90-day no action by the planning board, so it's in that realm. But the party, as in your case, for a long period of time doesn't bring a mandamus action, even though they could have, but they don't. I mean, isn't that your situation? So if the mandamus is rejected because, arguably, the party who was entitled to it sat on his or her or their hands, even though on the substantive law you may be right, aren't you out of luck?
Again, we're out of luck for subdivision control purposes. That is, without the certificate, we can't record the plan and proceed on the subdivision. But it would do far more violence to the statutory scheme to hold that we're also out of luck for zoning freeze purposes, as well as running contrary to the suggestion, and it's not the direct holding, of Heritage Park and Broken Stone. Let me turn, by way of further answers to both these sets of questions, to one point of statutory construction, because this is a point the appeals court ignored. The second sentence of 81V says, in the event of a constructive approval, you might have an appeal, you might have no appeal. If there's an appeal, it becomes final when the court says it became final. That is, the has become final language I quoted a moment ago. In that situation, in the same sentence, there is no suggestion, no way to read the statute to mean that the town clerk's certificate is the determinative act. It already became final by the time it reaches the town clerk's desk. And the ministerial act of issuing the
So
certificate.
you're saying it's the passage of time that makes it a final?
In the situation I was just talking about where there was an appeal, it's not the passage of time, but it's the resolution of that appeal, so that there are court records stating the appeal is dismissed. In the parallel situation, in the same sentence, it would be the passage of time. It's the 90 days for planning board action and filing of its certificate, not the town clerk's, plus 20 days for appeal. That's all relatively certain. There's no uncertainty there, and there's no reason to read the two halves of the same sentence differently, where in one half the town clerk's certificate is everything for zoning purposes, and in the other it's clearly not required for the zoning freeze.
But if that's true, what's the purpose of having the town clerk make a written certification?
Because the town clerk's certification enables the developer to proceed with its subdivision control rights. Not only its zoning rights, those are separate, and Heritage Park said don't confuse the two. But without the developer needs the certificate in order to record the plan and proceed with the subdivision, as most developers want to do. But they don't have to, as we know from Mass Broken Stone. And so the point is that is required for subdivision control purposes. It's in subdivision control law, but it's not required, in our view, for zoning freeze purposes, because that's a completely separate issue. And it's not required. It's not required by the language of 81V. Let me turn.
But the zone freeze is. I know it's geared. It identifies. It is identified with the land, but it's identified with the land that's described in a plan. So at least for procedural purposes, the plan still needs to be either endorsed or certified by the town clerk as having been constructively approved. Don't you need both? Don't you need a signature of one or the other?
I don't believe you do. If the appeal period runs, then you have your final approval, and the zoning freeze is in place. No one has to file anything. It's simply as a matter of law. You are then subject to the old zoning rather than new, presumably more restrictive zoning that may have even been adopted in response to your plans. So it is merely.
But then what do you do, though, about in Section 6, the language about 8 years from the date of the endorsement of such approval?
Well, again, that language refers to only the case where there was actual affirmative approval by the planning board. It doesn't refer at all to the situation where the planning board, as I said, neglected or failed to decide in time.
But doesn't it make a distinction between final approval and endorsement?
Does
Section 6.
No, Section 6 doesn't refer to endorsement at all. Section 6, I'm sorry, it refers to the endorsement of the board, but it simply refers to final approval as the trigger. And the reference to the endorsement of the board tells you when the 8-year zoning freeze starts.
Yeah,
but it's final approval that triggers that.
But that statute, Chapter 48, Section 6, 5th paragraph, refers to both. It says if the definitive plan or an amendment thereof is finally approved, and then it goes on to say for 8 years from the date of the endorsement of the approval.
Right.
Of such approval. So the statute seems to make a distinction between two events. One is the final approval, and the other is the endorsement of the board.
And it refers to the endorsement of the board only for the date. That's when the 8-year starts. You're absolutely right. It makes that distinction. Final approval does not require the endorsement of the board. Final approval is then set out in 81V as following in several circumstances, depending on whether you had actual vote or no vote, and whether you had an appeal from that or no appeal. But you're absolutely right. Final approval is independent of endorsement, and equally, or even more, independent of the town clerk's certificate where the planning board didn't endorse the plan or didn't act on the plan.
So when does the 8 years start to run?
The 8 years in the event of a constructive approval starts to run when the appeal period runs, that is after 20 days, because that's when the proposal, the project, has become, or I should say the application has become final. Now, that 8 years as in Heritage Park would be told by the pendency of litigation, and that may not be a simple matter for this court to resolve on this record. There's this case, there's previous litigation, et cetera. I want to turn just to one more point of policy and then conclude, if I may. The policy point, and this was stressed by the appeals court as well as by the defendants, is certainty and predictability. And there's no question the subdivision control law is drafted to foster those values, and that's important for developers, for residents, for municipal boards. But as I said, it's fairly certain and predictable in all but this bizarre cases. 90 days plus 20, that's when it became final. It's no less certain than if there was a town clerk certificate. In fact, it's more certain, because as we see from the Stockbridge cases attached to my supplemental brief in the appeals court, to wait and see if and when the town clerk will issue the certificate, whether there's a mandamus action, whether there's an appeal from the mandamus action, there could be years where literally no one knows whether zoning is frozen in that situation, if the town clerk's certificate were the key.
Mr. Krieger, I'm sorry your time is up.
Thank you, Your
You'll have
Honors.
to leave it there.
Good morning, Ronald Rappaport, town clerk. I'm town council for the town of Aquinnah, up early.
Not sure you want to be town clerk in this particular segment.
Well, I'll take it.
Why isn't that last suggestion really the most predictable and certain way to proceed? 90 plus 20. You got 90 days plus 20 days. That's easy to calculate. Zoning freeze starts to run.
Two reasons. Number one, that's not what the statute says. 48.6 is the only place where you get freeze protection, and 48.6 requires final approval and an endorsement. It requires.
But there's
two
no
events.
endorsement in a constructive approval context.
So
is
I
there?
think you have to read in the words. You have to do two things. You have to read in the word certificate, because the certificate is treated as a functional equivalent of an endorsement under 4181V.
But we could also read in the 20-day appeal period. And isn't the statute essentially designed to minimize these outrageous costs that developers would otherwise have to incur if town clerks simply didn't want to refuse, or simply refused to sign the certificate? Why should they have to incur the cost of a mandamus action?
2 points. One, you have, as I said, you'd have to read out the words of the statute. But second, look at the facts here, because the facts here answer that question. These property owners applied during the time that there was a moratorium, in which by the Marshfield Commission, the process could not start at the time that they filed. Under the Island Properties case, there was a freeze. So the clock never started. Second, they never filed properly with the town planning board, and that was referenced in all of our briefs and referenced in the appeals court decision below in the town clerk case. 418110 specifically requires that to start the clock, and if you want a constructive grant, you have to comply with the statute. To start the clock, you have to file at the meeting of a planning board, or you have to send registered mail to the planning board. That's 418110. That was not done here. The clock never started.
Did that issue get resolved in your favor in the first case?
It was resolved against us in the Superior Court,
Right.
but the Superior Court judge quoted the predecessor statute of 418110. The predecessor statute permitted there to be a registered mail sent to the planning board care of the town clerk. The legislature changed that, and the Superior Court never picked that up. We briefed that, and the appeals court in the town clerk case said, because you lose on latches or statute of limitations, we need not reach that issue. And then we had the same thing coming up in this case. I mean, the Superior Court and the appeals court went directly to the merits and said basically we don't need to reach that. So then the clock never started here, and that underscores the important role of the town clerk and the importance of a certificate, as this court has enunciated in several cases, including KV and Pembroke. A certificate is a document issued by a clerk that parties can rely on. It's a stake in the ground, and that's the role that the town clerk plays. And here, there would be no way to find out if the clock started or when it started. And that's
What if the clerk refuses to pound the stake into the ground, which seems to be this case?
Why did the town clerk do it?
When they do, what happens when the clerk refuses to pound the stake into the ground?
You bring a mandamus action, which has been done repeatedly.
And why should it be? Why should the burden be on the developer to do that?
Because that's the statutory scheme.
There's no mandamus action in the statutory scheme, is there?
Well, there isn't, but as the statutory scheme as interpreted by this court repeatedly in Pembroke and KV, in a whole host of cases, in the appeals court, that's the burden. So there has to be a stake in the ground so that everyone can rely on it. Title examiners, the zoning officers, not just the applicant. A lot of people have rights here. And a town clerk certificate is that stake, and the statute requires it. Their position...
But it's easy to calculate this. You have a date when there was a final plan, 90 days expires, there's been no action, the abutters know when they have to appeal, they have to do it within 20 days.
It's not easy here. And in this case, as I said, would demonstrate the rule. There was a freeze in place at the time that this plan was filed. How would anybody know that? There was a statutory freeze in place. And secondly, it wasn't filed in accordance with 41810. So the clock never started. Who was supposed to figure that out? You can't leave that to title examiners. You can't leave that to the zoning officer. You leave that to a court. And that's why there are repeated cases where people have brought mandamus actions to get certificates. Let me just go, if I could, go back to 40A6. 40A6.
Well, how can you get a mandamus action if there's no clear duty? If it's not clear to somebody that they have to file the certificate, how can there ever be a basis for a mandamus?
All I can do is repeat, is cite to the various cases where mandamus actions have been brought to compel the town clerk to issue a certificate. And what I point out, and I think is interesting, both in KV and in Pembroke, cases from the 60s, mandamus actions were brought. But not only did the court, particularly in KV, said, you really should have issued that certificate, but we're going to stay the issuance of the certificate for 60 days because we don't like blunders, and the planning board blundered its way into a constructive approval. We're going to stay our mandamus action, and you can go back to the planning board under 4181W. I mean, the planning board could reconsider, and within 60 days, if they vote to rescind the plan, we're going to dismiss the case. So this court has repeatedly expressed, we do not like constructive grants. If we have to order it, a certificate to issue, we'll do it, but we don't like it. And that's been a consistent policy of this court.
Well,
what
the
do you say
problem is
about-
the legislature likes them, and they're the ones that created the constructive approval statute, and it's pretty clear as to how it's supposed to work.
But the legislature is the one, again, that specifically said 2 steps have to happen for you to get a freeze. You have to have final approval, and that's defined under 4180V as the issuance, with the issuance of a certificate by the town clerk. That's the definition. Even look at the heading. I know you're not supposed to look at headings. If you look at the heading of 4181V, it's entitled final approval, and it occurs when the town clerk issues the certificate. 4181U just talks about approval. The plaintiffs would be in good position if they were here before 1965, because before 1965, that's when the word endorsement was added to 40A6. Before 1965, it just said upon approval.
Well, what do you say
You
about
get a
broken
freeze.
stone?
Broken Stone, I'm sorry, Broken Stone has nothing to, we say it's totally an absent. In Broken Stone, the preliminary plan was disapproved, then it was again disapproved, it was finally approved, and they applied for a new subdivision during the time it was on appeal. The statute specifically, and again, it was ultimately approved, overturned, and the court went on to say that because they were in the middle of their process freeze, because you get a process freeze until you get a statutory freeze, and the process freeze is when you're in process, that's all it said. You're in the middle of a process freeze, and you're entitled to the freeze. But once you get final approval and endorsement, you're then into the statutory freeze, and that's when the 8-year period comes in. So there's no harm to a developer. They are under a freeze as long as they are in process. And then they get a statutory freeze for 8 years when it's endorsed and final approval. You can't read final approval and endorsement out of the statute, as I
So
said.
those are 2 separate things.
Those are 2 separate things.
And endorsement equals certificate.
Equals a certificate, in my view, and I'd say in the view of this court in the various cases that they've cited. I'd also like to bring your attention to the Vaza case, which was referred to by Justice Lank in the decision below. And the court went through, this was in 1971, this was after the words endorsement were added. And at the end of the decision, they talk about when does the freeze begin and end. And they said, before, and this was right at the end, at the last paragraph, but they said before the words endorsement was added, the freeze began upon approval. Once the words endorsement were added, you need the endorsement before the statutory freeze can begin. These are words of significance. I cannot say how you can read the words final and endorsement out of the statute. Let me talk about, just briefly, public policy. Hope I'm not running out of my time. Public policy. There would be chaos, as I've referenced before, if you were to adopt the plaintiff's point of view. No one would know when that period began, as our case would demonstrate. We would have conflicting opinions of counsel. We'd have a zoning officer wouldn't know what to do. You need to have that certificate. And that's what the legislature had in mind when they said final approval and endorsement. You need to have a stake in the ground. People can challenge it. They can go to court. But there it is. It's right there. And they'd like to read that out. Also, I go back to KV doesn't like, this court has not liked constructive grants. They have sent them back for modifications and under 81W. It's not a good public policy because no one has put a stamp on whether the roads
That's a hard
are there.
argument to make, though, Mr. Rappaport.
I'm sorry?
It's not good public policy when it is specifically provided for in the statute, isn't it?
It's provided for, but what the courts have, they've been reluctant to say, go issue that certificate. Again, in KV, they said, let's hold for 60 days, go back and go to the planning board, because we're dealing with roads. And as long as we're dealing with roads, these properties have no access. They have no road on the ground to either property.
Counsel, can I ask you a question? You just referred
Yeah.
to a case called Baza.
I'm sorry, VAZZA.
Is that in your brief somewhere?
It's not. It's in the appeals court decision, Your Honor, below.
All right. All right. Thank
It's 359-256. And I direct your attention to the last page,
All
which
right.
is 263, 264.
Okay. Thank you.
So finally, let me just sum up, Your Honor. In conclusion, there's no access to this property. A certificate never issued and never can issue, and that's a decision that your court refused to look at twice, the town clerk decision. A certificate can never issue. There has never been final action. The appeals court did a good job, I feel, in this case, and there is not one case that they can direct you to which holds what they're arguing, that you get a freeze even where you cannot get a certificate. You get a freeze for 8 years. There's not a case, there's not an appellate case that has ever held that. And if you literally look at the language, you really don't even get a freeze on a constructive grant. We are not arguing that because we think certificate and endorsement are the functional equivalents.
Thank you, Mr.
So in bottom, thank you.
Good morning. Eric Wadlinger for the Martha's Vineyard Commission. First thing I'd like to say is that the petition for further appellate review, the plaintiff appellants did not seek further appellate review with respect to counts 3 and 4 of the complaint, which challenged the validity of 2 districts of critical planning concern enacted by the Martha's Vineyard Commission. So I would suggest that that issue is not before you.
So you, I'm not being flip, but in other words, you're just here sort of as belt and suspenders. You say we should never get to you. Is that right?
Yes, Your Honor. And as Justice Houston noted below, there was no evidence offered to rebut the statutory presumption of validity, which attaches to those 2 legislative enactments by the Commission. On the question of the zoning freeze, I'd like to advert to one issue which the Court asked about before, which is sort of, isn't the 90 and the 20-day period easy to calculate? Doesn't that provide a ready yardstick for everyone? I think the answer is generally not, because in general, subdivision plans, particularly large subdivision plans, are not disposed of in 90 days. There are continuances requested and granted, and once that happens, it makes it very difficult for the public to know when is the period during which that 90-day constructive approval period should be measured.
But doesn't the statute require those agreements for extension to be filed with the town clerk?
They do require them to be filed with the
So all you have to do is go to the town clerk's office within 90 days after the definitive plan was filed. If there's no agreement to continue, that's the end of the ballgame, isn't it?
I think, Your Honor, if you're dealing with all of the parties in interest here, which are typically abutters as well as the applicant, that is a burden which most abutters will not do, whereas they can go and find out whether a certificate is issued very easily, whereas going to the planning board records and pouring through them to find a letter requesting an extension or a signed extension agreement from the applicant is not something most abutters will do. The other point is that the regularity of the records.
Well, how can you ever win a mandamus action in one of these cases then, if what you say is true?
KV was a mandamus order issued, and this court upheld that mandamus order.
But there has to be a clear order of the violation of a clear duty. How can there ever be a clear duty in these circumstances? I mean, don't you? Aren't there just two operative dates? The date that the definitive plan is filed, and 90 days after that. If there's nothing, if the planning board has not, then you go to the planning board minutes and see if there's been a vote. And if not, you'll go to the town clerk to see if there's been a certificate or agreement of an extension of time.
May I respond, Your Honor?
Yes, please.
I think the point here is that if there has been the 90 days have passed, then the question becomes, has an appeal been filed? Has that appeal been finally resolved? And the only way to have that enter, that stake in the ground, if you will, definitively, where everyone can find it, is to get a certificate from the clerk, because that ends any dispute. Everyone knows where to go and where to look. And that's the function of the town clerk, is to provide that central recording place where these issues can be definitively resolved.
Well, I guess that may be fine with respect to subdivision issues, but what about the freeze? Why is that? Why should that apply equally to the freeze?
That is a question of statutory construction, and I think the point is that Section 6 of 40A was amended to add the word final approval. And as town council noted, 81U speaks of approval, but 81V speaks of final approval. And so the legislature has drawn a distinction between those two. And when they amended 40A Section 6 to, it initially said in 1961, when a plan becomes approved for 5 years from the date of such approval. It now reads, when a plan is finally approved for 8 years from the date of endorsement of such approval. So the legislature was addressing a perceived problem of ambiguity arising from the earlier formulation. And that is in the Zoning Act, 40A. That is not in the Subdivision Control Act. So I think that question is really resolved, not by me arguing policy, but by the legislature's wording.
All right, thank you very much, Counsel.
Thank you.